Welcome everyone to this WSG session. Before introducing the panelists, a few words about the topic. Trade secrets have become a central pillar of modern IP strategy in both US and Canada, often sitting at the intersection of IP, employment mobility, cybersecurity, and commercial litigation. The result is a fast-evolving, high-stakes area of disputes. In both countries, we are seeing a sustained rise in trade secret claims against former employees, competitors, joint venture partners, and service providers, where the issues are rarely limited to what was taken, but extend to access controls, evidence preservation, the scope of confidentiality agreements, and the remedies required to prevent continued use. This momentum is not likely to slow. If anything, the growing integration of AI into product development and operations is adding fuel. More valuable proprietary data, models, prompts, and workflows, more tools that can replicate or accelerate know-how, and more difficult questions about what constitutes misappropriation, how to trace it, and how to craft effective contract clauses in a world where information moves instantly. To guide us through this landscape, we are fortunate to have two panelists who have prepared an excellent presentation. They are deeply knowledgeable, and they have been notably passionate about the subject for good reasons, because trade secrets litigation is increasingly where competitive advantage is won or lost on both sides of the border. Let me introduce you to our panelists. Julie Simeon is a partner of the firm Patterson Belknap in the litigation department. She represents clients in legal malpractice cases, as well as in cases arising from complex financial transactions, cryptocurrency matters, and large-scale litigation, as well as those involving government investigation and bankruptcy proceedings. Her representation extends across a variety of IP matters, namely trade secrets, copyrights, patent, and trademark disputes. From 2016 to 2017, Ms. Simeon served as a law clerk to the Honorable Eric Vitaliano of the U.S. District Court for the Eastern District of New York. James Duffy is a senior associate lawyer and a patent agent at the firm Lavery. James holds a degree in honors chemistry from McGill, where he graduated with first-class honors and on the dean's list. James is also a graduate of McGill's Faculty of Law. James' main areas of practice are IP litigation and patent prosecution. As a litigator, James has acted in several complex IP litigation files, including multi-jurisdictional files, clients in various industries such as pharma, electronics, and entertainment. He has represented clients in litigation files involving patents, trademarks, industrial design, and copyrights, both before the Quebec courts and the Federal Court of Canada. As a patent agent involved in patent drafting and prosecution, James' main areas of practice are chemistry, materials, energy management and conservation, mechanical engineering, and metallurgy. I invite you to ask your questions in the Q&A, and the panelists will answer them at the end. Let's hear from our panelists.
Great, thank you, Chantal. As Chantal said, my name is Julie Simeon. I practice at Patterson Belknap, Webb & Tyler in New York, and I'm just very excited to be here. Thank you to the WSG, James and Chantal. It's been great putting this together with you. So we're going to spend about 60 minutes today discussing trade secrets. So we thought it made sense to discuss at the outset what a trade secret is and what it's not. We have here the definition of a trade secret from the Defend Trade Secret Act, or the DTSA. This is the federal statute in the US under which most trade secret litigation is brought these days. We'll talk more about that later, but let's first look at what can qualify as a trade secret under it. You see it encompasses financial and technical information, methods as well as codes, plans, products, designs, formulas. In fact, the classic example you'll hear of something consisting of a trade secret is the recipe for Coca-Cola. And under this definition, which is similar to what is used in Canada from what I understand, a trade secret can be tangible or intangible. It can be an invisible asset. So the scope of what could potentially qualify as a trade secret is quite broad. However, there are two things to keep in mind, even when you're thinking just about the foundational question of what a trade secret is. First, to be a trade secret, the owner of the trade secret must have taken reasonable measures to keep that information secret. What did it do to protect it? And second, the information must have independent economic value that is from not being known or ascertainable by a person who can get value from it. And in reality, it's really these two prongs where most of the work gets done in trade secret law. Where a dispute might be about a formula or a technique, courts in the US are very quick to move to these two considerations. Now, there's 6 factors in the US that courts will sort of ask and answer in considering these questions, but 4 of them relate directly to this idea of secrecy. Whether the information can be known outside of the business or is known outside of the business, and how a company has or has not worked to keep that information secret. And on that last piece, at the beginning of a case, it's really imperative that a plaintiff, a trade secret owner, be able to identify and allege the steps and the processes that the company took to keep the information secret. And sort of by way of example of this, there was a very recent case in the US where some employees of one bank left to work at another bank. These employees allegedly took confidential information from the prior employee, or prior employer rather, and began targeting Bank One's customers. This court sort of quoted the 6 factors and then turned to the measures very quickly that the Bank One had taken to protect this information. They required confidentiality and non-disclosure agreements, trained the employees on their confidentiality and NDA obligations, and importantly, had imposed various restrictions on use of software that would allow the information to sort of seep out in the way that it had in this case. And the court found that Bank One had sufficiently alleged, at least at that stage, that the information was protected in order to be secret. And then kind of on the flip side, there was also a very recent case in the 10th Circuit in the United States where the appellate court found the opposite. The appellate court found that the plaintiff had not protected the trade secret. The plaintiff claimed that it protected the information, in this case it was a customer list, by keeping the information on a password-protected laptop. But the court found this not sufficient. The plaintiff did not require employees to sign confidentiality agreements. The plaintiff had shared the information with multiple employees without notice to those employees. That's very important, notice that the information was confidential. And the information itself, as opposed to just the laptop, was not password protected. So it's probably intuitive given the title, but the secrecy aspect of trade secrets is a key characteristic that often distinguishes it from other forms of protectable intellectual property. Trade secrets derive their value precisely from being hidden. And this is a distinction that makes trade secrets sort of a complement and in times a contrast to other types of IP protection, like those that come with patent and copyright law. So this lends itself to a natural transition. I'm going to turn it over to James to talk a bit about the intersection of patents and trade secrets.
Thanks, Julie. And yes, that was a very natural transition. First up, as Chantal said, my name is James Duffy. I work as a lawyer and a patent agent at Lavery Avocat. And just as Julie talked a lot about what trade secrets are, we thought it would be important to sort of briefly discuss what they are not. And what they are not are patents. Although for any patentable invention, there usually is that choice of whether you want to actually go the patent application route or the trade secret route. And very often trade secrets and patents are described as being 2 sides of the same coin, because for any inventive piece of technology, generally speaking, you can only pick one type of IP protection, patents or trade secrets, but not the other. The reason why is because anytime you draft and file a patent application, that patent application is going to describe the inventive technology in a manner that allows people to replicate it and to understand how it works. And patent applications are published after 18 months from filing. So after 18 months, the patent application becomes publicly available, and at that point, it becomes quite difficult to argue that the invention should be considered a trade secret, because obviously it's not really a secret anymore. So when deciding whether or not to go the patent or the trade secret route, each side has its own advantages and disadvantages. For example, patents generally last 20 years from filing. However, trade secrets can last indefinitely. I say can, the word can is bolded because while indefinitely can mean forever, it can mean a lot longer than 20 years. That isn't always the case. And in fact, trade secrets can sometimes last for a very short period of time. They last for as long as the information itself remains secret. Another advantage or disadvantage that you have to consider is the costs associated with each avenue of protection. So anytime you file or draft a patent application, there are going to be costs associated with the filing and the maintaining of the patent application and the resulting patent. Those should be compared with the costs of maintaining the trade secret. It always costs money to implement an infrastructure necessary to both manage and maintain trade secrets, and those should be compared with the general costs associated with filing and maintaining patent applications. Another consideration is subject matter restrictions. So for example, software-related inventions, while they can be patentable, sometimes they are a bit more difficult to patent than other forms of technology. And so a lot of people generally for software-related inventions try to go the trade secret route rather than filing a patent application. Similarly, technology that is easily reverse engineered, at that point in time, it might not make sense to try and keep it a trade secret if that information can be easily discoverable by third parties. And so maybe you would want to go the patent application route. I do want to say that even though for the same piece of technology, trade secrets and patents are generally mutually exclusive from each other, there can be some overlap. So for example, if you have a trade secret process and one of the steps in that process uses a device, that device maybe could be patented because as long as the rest of the process remains a trade secret, you could still argue that the process as a whole is a trade secret. Similarly, if you have a patented system, it could be that one or several of the modules in that system use trade secret software. And so that would be an example of, overlap between patents and trade secrets where they can both coexist simultaneously for related technology. So the next thing that Julie and I wanted to discuss in our presentation are the main legal bases for trade secret claims, both in Canada and the US. I will obviously be talking about the Canadian portion of trade secret claims. What's important to remember in Canada is that unlike in the US, as Julie mentioned, the Defend Trade Secrets Act, we do not actually have a federal statute governing trade secrets in Canada. We have a Patent Act, a Trademarks Act, a Copyright Act, and an Industrial Design Act, but we do not have a Trade Secrets Act. And that actually has two major consequences, I would say. The first is that generally when you institute a trade secret claim in Canada, it's going to be based on a more general type of civil action. And it isn't going to be called, for example, a specific trade secret claim. So as an example here, in common law provinces, so those would be the non-Quebec provinces in Canada, there are several types of civil actions for trade secrets, and those include breach of contract, breach of trust, breach of fiduciary duty, unjust enrichment, and interference with contractual obligations. Just to give an example of what I mean, if you sign an NDA with another party, there's a contract regulating the relationship between those two parties. And if they misappropriate your trade secrets, you can argue that there was a general breach of contract. So your claim isn't going to be, a specifically trade secret related claim. It's going to be a general breach of contract claim that encompasses breach of trade secrets. In Quebec, it's similar. We have our civil law system in Quebec relying on our civil code. And you can base trade secret claims on general breaches of contract. You can breach them on violation of an employee's duty of loyalty towards their employer. So that is under Article 2088 of the Civil Code. We also have an article in the Civil Code that relates specifically to trade secrets. This would be Article 1612. So that is one example of a trade secret claim in Quebec that actually is specifically for trade secrets. But overall, you're likely going to be relying a lot on those, more general types of actions like breach of contract. The other consequence to not having a federal statute governing trade secrets is that trade secret claims generally cannot be brought in federal courts in Canada. You are going to be bringing them forth in superior provincial courts. And the reason why is because our superior courts are courts of inherent jurisdiction, and federal courts can only hear matters to which they have been explicitly granted jurisdiction. However, federal courts can hear trade secret matters if the action involving the trade secret matter also involves something that the federal courts can hear. So, for example, if you're instituting an action in patent infringement or copyright infringement, and there's a trade secret violation component to that action, then the federal courts could actually hear the trade secret claim in that case. But in general, you're going to be bringing them forth in superior court. I did want to mention one thing as well. In Canada, very recently, we instituted criminal law remedies dealing specifically with trade secrets. This would be Section 391 of the Criminal Code. Previously, criminal sanctions regarding theft of trade secrets were dealt with under the general provisions relating to fraud, and was only because of CUSMA, or the United States-Mexico-Canada Agreement, that these specific trade secret related criminal code provisions were added to our criminal code. And so I will let Julie talk about trade secret claims in the United States now.
Thanks, James. So in the United States, there's been a progression from a common law, kind of disparate legal system to protect trade secrets to a more statutory unified system, albeit still having distinctions across the country. So to kind of set the stage for the United States, because there's been a lot of development in the last few years, 45 years ago, there was no uniform statutory system that governed trade secret law in the US. Around this time, you had 50 states with various common law solutions. Some of the laws sounded in tort law. So for example, in New York, we have a thing called idea misappropriation, and a plaintiff can bring a claim for idea misappropriation in very particular contexts when you're fighting about an idea that's novel and concrete. Some of the laws were based in contract, as James alluded to. It was and still is common to have a breach of contract claim brought against employees who are alleged to have breached their confidentiality agreements with former employees. These often float alongside trade secret claims still today. But what this resulted in roughly 45 years ago was a very disjointed system where different states not only had different standards, but also had laws emanating from very different sources: tort law, contract law, property law. And the available remedies were really quite different as well. So injunctive relief is going to be available in some places, but not others. Oftentimes, the scope of that injunctive relief was quite different. Monetary relief, generally available, but what needed to be shown was very different from state to state. Punitive damages, available someplace, not others. Attorney's fees, not generally, but sometimes. And the patchwork system became increasingly difficult. Companies had growing national and global reaches at this time, and those companies were struggling, as your clients or you may have done at some point, to understand what it needed to do to protect trade secrets on a larger scale. And this need to reconcile some of these differences really didn't go unnoticed. In the late 70s, the Uniform Law Commission in the US approved what is called the Uniform Trade Secret Act, or UTSA, as people refer to it sometimes. It was a model act. It didn't have the force of law anywhere, but it was available to the states with the message that it was the product of many years of reviewing these various laws, the various sources of laws that related to trade secrets. And it was meant to codify the results of the better reasoned cases, as some courts have put it. It would put everything into one statute that states could take off the shelf and could hopefully amend to their liking and adopt in the various states. And that's exactly what happened. Many states adopted the UTSA in their state, some with modifications, others without. And in fact, 48 states have now adopted it, with my state, New York, being one of the lone holdouts alongside North Carolina, which is a similar, though not exactly the same, UTSA statute. And one of the most critical things to think about at this time is that the Model Act brought cohesion, a cohesive definition of trade secrets to trade secret law in the United States. It took those two prongs that we discussed early on at the outset of the talk, and it baked them into the definition of trade secrets. Trade secret had to be information that derived independent value from not being generally known. And this was really an intellectual push away from a discussion about what type of information can be trade secret to one about the economic value that's derived by the information and how that relates to its sort of trade secretness. And then the second thing that really happened here was that UTSA codified, in a sense, that there had to be reasonable efforts to maintain the secrecy of the information for it to be entitled to protection. And this has 2 points unto itself. This really shifted the onus onto the company asserting a right in trade secrets to demonstrate, not through registration or certification like other forms of IP, but through its actions and conduct, that these assets were valuable. And then again, it also served the function of putting employees or those persons who might be in a position to take trade secrets on notice that the information was considered valuable and secret. And I should note there is a balancing that companies need to consider when they think about contemplating secrecy measures. There's a case in the United States called Rockwell Graphic that's really cited for this proposition all the time. But what happened there was a drawing that was in dispute, and Judge Posner in the United States was sort of pontificating on what needed to be done to adequately protect this drawing of manufacturing parts. And he said, you could just have one copy and never copy that drawing, but what would that actually require? Like all of the engineers being in the same room at all times when discussing this piece of information. And so perfect security is not always optimal security, but there will be contextual variations between companies and what they should do to protect their assets. And then finally, that brings us to 2016 and the DTSA. The DTSA was signed into law in May of 2016, so almost exactly 10 years ago. It created a federal civil cause of action for the misappropriation of trade secrets. And on substance, it was modeled on UTSA, and it adopted many of the definitions wholesale from the Model Act. So it wasn't really starting anew. And a lot of people have asked, like, why? Why did this happen at this time? The U.S. had kind of trudged along for decades without federal civil causes of action for trade secrets. And there's kind of two things that were quite important around this time. There was simply a greater need to protect trade secrets because they became easier to take. By 2016, we're living in a world where there's immense amounts of data that could be transferred very quickly in a matter of seconds. But we're also living in a world where it was very likely that you were able to put a flash drive or a thumb drive into your laptop and remove documents from it in the ordinary course, which, spoiler alert, not best practices. There should be ways to sort of lock that information down if you're going to demonstrate secrecy. And then the second thing is that there were limits on the remedies that state courts could issue. Even though there was greater standardization across the content of the law in the United States, given the wide adoption of UTSA, state courts could not issue nationwide injunctions, and they couldn't issue remedies that had broader reaches. And so before we move on from this, I wanted to kind of highlight 3 data points that I find super interesting about the DTSA. Since the enactment of the DTSA, almost 10,000 cases, more than 9,500 and less than 10,000, have been filed in district courts across the United States, with some resulting in rather substantial monetary awards in the $500 million range. So this isn't a statue that's just sitting around gathering dust. Second point, in 2025, 90% of new federal trade secret cases had other causes of actions besides the trade secret misappropriation asserted alongside. And this really just highlights sort of what James was referring to as well. This wasn't creating an entirely new right. It was really building on common law rights, state statutory rights, and pairing those alongside a federal civil statute. And in fact, most cases in the United States still have a classic lineup of claims: common law claims, state UTSA claims, and then of course the DTSA. And then finally, from 2023 to 2025, it's reported that close to 65% of federal trade secret cases end in likely settlement. And this should be unsurprising, since many of the cases in the United States involving trade secret litigation involve requests for preliminary injunctive relief. And once that aspect of the case is resolved and the court has weighed in on the likely merits of the case, cases tend to resolve, which brings us to our next slide here about the process that these cases typically travel. So When disputes about trade secrets are brought, what is the standard sequence of events? And more importantly, what is the standard sequence of events that every company or each of your clients needs to be prepared for? Once it becomes apparent that someone has taken or is likely taken a trade secret, it's common for the trade secret owner to send a cease and desist letter. This is, of course, the cautionary letter that sets out a description of the alleged wrong conduct, the rights that are perceived to be violated, and then demands that the conduct in question stops. And this should be done ASAP. It should be short. It should be to the point. And I know many companies have just a template C&D letter that they will use to avoid having to make kind of wordsmithing decisions when it's really time is of the essence in these situations. Assuming this doesn't end the dispute, and it often does not, it's common in trade secret matters for plaintiffs to seek some form of preliminary injunctive relief. This is where the plaintiff asks the court to stop conduct at the outset of the case, either through a temporary restraining order or a TRO, or a preliminary injunction, or often both. And seeking a TRO or a PI is a very serious matter. Courts in the United States routinely refer to this as an extraordinary remedy. They're also a way to quickly escalate for both sides the speed and the immediate costs of the dispute. So I wanted to sort of talk about the things to think about from both the plaintiff and the defendant side when you're involved in a request for preliminary injunctive relief. As a plaintiff company in the US, you're effectively fast tracking your case when you file an application for a PI or TRO. There's a 4-part test in most jurisdictions in the US, but the reality is it often comes down to 2 things as a plaintiff. Can you, as the trade secret holder, demonstrate that you're likely to succeed on your claims? So all of the things we've been talking about secrecy and value of the information, and of course, whether the information was used, all of these are going to have to be demonstrated very early on in the case. And can you, as the trade secret holder, demonstrate that you will suffer irreparable harm absent an injunction? Money damages just won't do here. And on the merits piece, a trade secret holder carries the burden of persuasion on her claims at this point. And this is in stark contrast to the typical American litigation where you sort of slog through months or heaven forbid, years of discovery before you have a similar burden. Here you need to come forward with evidence to convince a judge that you're likely to succeed on the merits of your claim right out of the gate. This can be done in the form of affidavits, declarations, but very often in the United States, it's going to involve a full-blown hearing where documentary evidence is introduced and witnesses are called. Fact witnesses might testify to the potential misconduct, who had access to the confidential information at various times. The company's policies and procedures come into play at this point. An expert witness can explain why the materials are considered trade secret or not. What's the sort of public value of this information? Is it available to the public? Or can explain why a security protocol that was in place may or may not be appropriate in these circumstances. And then also, as the trade secret holder, you have to be prepared to articulate early on in these proceedings what the alleged trade secret is. This might be intuitive, but more ink has really been spilled on this particular issue in the US than you would think. Some federal courts in the United States take the position that early identification of trade secrets is really critical and imperative for an application for a preliminary injunction. And they will require plaintiffs, both in a PI and oftentimes in the case itself, PI or no PI, to come forward with this articulation. The Fourth Circuit, for example, has this sort of heightened requirement. You need, as the plaintiff, to be able to come to the court and say, this is what the trade secret was, these were all of the secrecy measures, this is the independent economic value, and articulate that in a very specific way. In the Ninth Circuit, though, the burden there often isn't quite as heavy. So you are often later in the case before this requirement is required of the plaintiff. So I guess the conclusion on this piece is, since you never can be sure where you're going to be embroiled in litigation, it is really best practice for companies to keep track of their trade secrets and invest the time and resources before a breach occurs to know what the company considers trade secret. And then when you do bring a trade secret case, make sure you know what the court's going to expect of you and when that expectation is going to need to be met. And now say your client is the person on the other side of the aisle. This is the person that is alleged to have taken the information. What do you need to be thinking about in a TRO or a PI? This may seem intuitive, But when being accused of trade secret misappropriation, a defendant needs to understand early on what its defenses are. Was the information comprised of public information in whole or part? Is the information readily ascertainable? And oftentimes, in order to figure out these defenses, you'll need to push for a more particularized articulation from the plaintiff of what the trade secrets are. Because how can you figure out if the information is public available or if the trade secret information is ascertainable if you don't have a full articulation of what it is? And then second, for a would-be defendant here, every company should be in a position such that it can work with either an internal or an external forensic team to quarantine or ring fence those materials that are the subject of a dispute. This gives defendants sort of a powerful argument at the early stages that even if a plaintiff had trade secrets, which you don't have to concede, that information has been locked down and quarantined in a way that will make the application for a preliminary injunction almost very difficult to obtain. And this is because there's no irreparable harm if this information in many situations has been locked down and quarantined. And so, as mentioned before, PIs are often precursors to settlement. So it is very important to sort of think about these things and think about how a company or your client should be advised in these they're very fast-paced moving situations.
Yeah, and just to add my Canadian perspective to preliminary injunctive relief, I wanted to say that, it works quite similarly in Canada, although they operate under different names. So, for example, in Quebec, we have what is called a provisional injunction, which lasts 10 days, and we have interlocutory injunctions, which last until trial on the merits. In Ontario, I believe the provisional injunctions are called interim injunctions. And the criteria for the injunctions I mentioned in Quebec are quite similar to what Julie was talking about in the US, but there are some differences. So, for example, in Quebec, the provisional injunction, one of the criterion to establish is that the situation is urgent. Which is sort of indirectly addressed in the US, it seems, from what Julie was mentioning, but in Quebec, it actually is one of the official criteria you have to meet. And one way in which the court evaluates whether the situation is urgent is how hastily you, as the plaintiff, acted in this matter. Generally speaking, once you find out you need to make this application for a provisional injunction, you have 1 month to file your application. And if you don't do it in that month, the court isn't really going to be convinced that the situation is urgent because you certainly didn't act with any sense of urgency. Once you have the provisional injunction, usually you're supposed to use those 10 days to file your application for an interlocutory injunction. Although we don't also in Quebec have what are known as safeguard orders, which are like interlocutory injunctions, except they only last 6 months and they're supposed to be renewed until the trial on the merits. One thing to mention, I mentioned previously that in Canada, you are going to be bringing your trade secret claims in Superior Court or provincial courts, superior courts, and not federal courts. Another reason for that is because federal courts in Canada are very reluctant to grant this sort of preliminary injunctive relief. So if the goal of your trade secret claim is to obtain preliminary injunctive relief, then superior courts are the way to go. Naturally, though, because you're dealing with provincial courts, you're going to be dealing with the deadlines and the rules on evidence that are related to that particular province. Another thing that I did want to mention is in terms of a type of preliminary injunctive relief available in Canada is Anton Pillar orders. So Anton Pillar orders in Canada are a very extreme form of injunctive relief. It's an ex parte application filed from by the plaintiff that allows them to actually, catch the defendant off guard, but actually go and seize evidence or materials held by the defendant. And it is quite extreme. And one of the reason it's granted, and in fact, it's one of the criteria you need to establish to have it granted, is that you need to establish that there is a reasonable possibility or a likelihood that evidence that is being held by the defendants, not only does it exist, but it is likely to be destroyed by the defendants if they were to learn that there was some sort of action that was going to be instituted against them. So that, that I think covers my comments in terms of preliminary injunctive relief in Canada.
Yeah, no, James, that's very interesting. On the urgency point, that's a good note. Whereas it's not sort of a standout it's not one of the 4 things that are listed on the slide. It's absolutely something that U.S. courts will think about. If you as a trade secret owner or plaintiff wait, many months to approach a court or a year and then seek a preliminary injunction or a TRO, which sort of track with some of the components that you were talking about available under Canadian law, you're not going to be met with a good reception from the court there.
Actually, one thing I did want to mention is in Canada, we don't have to establish a substantial likelihood of success on the merits. What we have to establish is more an appearance of right. And what's interesting is depending on whether that appearance of right is clear or just possible, the other factors that you have to look at, irreparable harm or balance of harms are going to be treated differently. So.
Yep. So the next, we're going to shift gears a bit, and we wanted to touch on some practical tools to protect trade secrets that companies can consider using. Some of these have been referenced already today, but we thought it would be good to take a moment and sort of talk through some of these things that companies or your clients might consider doing in order to demonstrate the appropriate secrecy was put in place. And we thought it would make sense to think about this from 2 points in time. When the company is hiring an employee, and then when that employee is then leaving. So first, when a company hires a new employee, what are some of the ways that the company can convey to that employee the sensitivity of the information that they will encounter? There's, of course, non-disclosure agreements and confidentiality agreements. These are the contracts between the trade secret owner and the employee or the third party, wherein the signing party promises not to disclose certain information, even after the employment relationship has ended. Now, you may be wondering how you can prohibit employees from using their general knowledge and skills going forward. And the short answer, at least in the US, is that you cannot. But courts have held that confidentiality agreements and NDAs are enforceable if they do not prohibit the employee's use of her general knowledge and skills. So the prohibition has to be on not using those things your company considers to be trade secret, which is just another endorsement for making sure that the company understands what those trade secrets are. The line sometimes between distinguishing between an employee's general knowledge or a skill, knowledge or skill, and employer's protectable trade secret, though, is often very difficult. And it's going to be hard to parse out what that skill and knowledge is versus what the trade secrets are in some situations. But again, very, very important to do, because a plaintiff coming to a court and seeking an injunction that places restrictions on someone's current employment, at least under the DTSA, is going to need to articulate what information that former employee should not be permitted to use in the new job. Because seeking a sweeping injunction, at least under the DTSA, that prohibits employment entirely is not going to work well in the United States. Then there are non-solicits and non-compete agreements. In the United States, non-competes in particular are a very thorny legal topic that are deserving of a webinar all to themselves. But these are both ways to control not the flow of information per se, but the flow of employees and hence the flow of information. So whether or not a non-compete tool is available to your client will vary state by state. Some states have complete bans on non-compete agreements. Other states have partial restrictions. So for example, that the non-compete be reasonable in scope. And interestingly, some states have restrictions that are starting to collapse non-competes and NDAs kind of into themselves by making non-competes void unless the non-compete protects a legitimate business interest. And this legitimate business interest is often defined to include protecting trade secrets. So they sort of become, when defined in a certain way and restricted in a certain way, they start to merge onto the same protectability. Now, the next question is, what are the steps that a company can take to ensure that the employee leaving does not send themselves or take home confidential materials or trade secrets? And the first thing we'd highlight here is exit protocols. Make sure your clients, make sure companies have developed robust exit protocols. These can go a long way to protect information. For example, conduct exit interviews. Give employees a copy of the most recent confidentiality agreement or NDA she signed and explain that she continues to be bound by it even after departing. ask the departing employee what specific confidential information or trade secrets she had while she was working at a company. And this is important. This is the second piece of this. Document that list. You can even have employees sign, in particular situations, a certification upon departure, confirming that they've returned all of the company's materials, deleted local files, understand that they're under this continued obligation to keep preserving this information. And those are some of the things you can do with the departing employee. But there's also things that companies can do without involving the departing employee. So make sure to do a forensic preservation or take a digital footprint of a departing employee's devices. Employers sometimes erase a departing employee's computer and then sort of repurpose that. And in some situations, in context cost, that may make sense. But consider having a forensic copy made of hard drives and preserving this for a certain period of time, especially for employees who have access to particularly sensitive information. Companies can also conduct forensic examinations, which will show if they have access to this information. When a USB was inserted, they can show when items were viewed and copied and give access to certain deleted emails. And then finally, post-departure confidentiality reminders. This is just a formal communication sent to a former employee, reiterating their ongoing obligations to abide by trade secret confidentiality and confidentiality for other intellectual property. They're becoming more and more common, and they're quite easy to draft and have at the ready.
So we also just wanted to touch briefly upon situations involving major transactions or endeavors with third parties, because these are situations that are likely going to involve the sharing of trade secrets. And I'm talking, of course, situations like joint developments or research and development collaborations where you are going to be working with another business or entity to, either create trade secrets or share trade secret information. And one thing I would say that is very important for these sorts of relationships is always make sure that you have contractual terms in place that for the ownership and control of any improvements or any intellectual property, including trade secrets that are developed as a result of this relationship. Another thing that is very important is make sure that this agreement has confidentiality boundaries that are clear and detailed. I say this, it might seem obvious, but very often, sometimes, in a joint venture agreement or some sort of research and development collaboration agreement, you see the NDA portion of the agreement, and it's just a very general clause that states that the parties owe a duty of confidentiality to each other. So it's important to have clauses that are clear and detailed that spell out these confidentiality boundaries. Which brings me to the next thing I wanted to discuss, which is when you're drafting one of these NDAs, which clauses matter most? And I always tell people this is a very lawyer answer, but all of them matter. It's why they're there. But if I had to pick three that matter most, well, I would say they matter most for this case because these are the types of clauses that are most going to be needed to be adapted for a specific factual scenario. Some of the other clauses you'll have are more likely going to be boilerplate, and these three clauses are going to be ones that you're going to have to adapt to a specific situation and maybe adapt a lot. So first one is a definition of trade secret information. Very often these sorts of definitions are going to be both broad and narrow, and the narrow portion of the definition is the one that you're going to want to adapt to your specific scenario and make sure that it fully captures the trade secret information that you think is most relevant to this NDA. The other type of clause that is very important is the use clause. Make sure that the use clause is restricted to a specific purpose. You are providing this trade secret information to a recipient for a reason, and you want to make sure that that reason is specifically defined in the use clause, and that the clause also makes it clear that the trade secret information cannot be used for any other purpose. And finally, the term of the confidentiality obligation should be clear. Again, it may seem intuitive, but the amount of NDAs I see without some sort of term indicated is quite high, or certainly more frequent than I would like. So, regardless of whether you decide the trade secret obligation should be indefinite or maybe last a certain number of years after the relationship terminates with the other party, it should be specified in the NDA. Another situation I wanted to touch on is, and this does happen quite frequently, is if ever you're participating in some sort of merger and acquisition or some sort of due diligence for an investment opportunity, one thing that usually has to be done is that there has to be a verification that the target's trade secrets are actually being properly protected and properly safeguarded. I know that this is a part of my practice. I'm brought into due diligences and I verify whether the target company is properly maintaining and managing their trade secret information. And in terms of what to keep in mind in the eventual scenario where that does happen, there are certain things that are important for your company to be doing. And one of them, and this was said by Julie multiple times already, is keep track of what your trade secrets are. And this involves keeping track of how you're using them and how important they are for your business. Another thing to keep track of is to whom you have been providing these trade secrets, and also making sure that all the recipients of these trade secrets are signing appropriate NDAs. So I would say that this is a good first step, because if ever your company is involved in a due diligence, these are some of the questions that you are going to be asked and that you're going to have to answer. And if you are able to answer them properly, because you have been keeping track of your trade secrets and to whom you've been providing them and making everyone sign NDAs, then that is going to mean fewer red flags are going to be brought up during this due diligence.
Yeah, and it is a common theme that seems like it runs across due diligence and litigation. Know your trade secrets.
Yes.
Be able to identify them during the diligence process, be able to articulate them in litigation.
Absolutely.
So we've touched on some of these common defenses to trade secret misappropriation. So we'll go through them here. What we have here is a list of the more common defenses to trade secret misappropriation. They're certainly not all of them. And the first two we've touched on, but under the DTSA, these are really just the flip side of the two prongs that a plaintiff needs to show in order to demonstrate that they actually possess a trade secret. A trade secret owner for public domain needs to show that information is not generally known or readily ascertainable. Conversely, when a defendant can show that the information is public knowledge or generally known in the industry, it can defeat allegations of trade secret misappropriation. And this is usually a more nuanced inquiry than simply whether a plaintiff has provided the information to the public or not. James referenced sort of some products cases and the sort of like the issue of trade secrets and products. In a products case, a company may not publicly sell or display a product and then claim trade secret protection in the information that's readily ascertainable, like dimensions of the product. But, and there's always a but, if acquisition of the information through an examination of the product would be difficult or costly or time consuming or some combination of those, courts say that trade secret owners can retain protection against an improper use. So it can be a bit of a thorny question. Inadequate protection. This is what we've touched on a few times today already. A defendant can argue that the plaintiff has not taken reasonable steps to protect the information. This is just the flip side of the plaintiff's burden to show that it has taken reasonable measures to protect information. Now, consent lawful acquisition. We've been talking a lot today about the scenario where an employee leaves with information that a former employer considers trade secrets. And in this situation, there's generally not a strong argument that the employee has consent or a license to use that information, but that's certainly not the only situation in which trade secret litigation arises. As James mentioned, this can happen in a variety of contexts, including in contracts that you enter into with vendors or potential partners. So another common scenario is where Company A enters into an agreement with Company B. Company A shares with Company B trade secrets, and then Company B uses that information in a way that's alleged to not be within the scope of the agreement. And in this case, the Company B will likely have a consent defense. And to be sure, the text of the DTSA explicitly states that the use of trade secrets constitutes misappropriation only if said use occurred without express or implied consent. there was a case in Massachusetts recently where a court dismissed the plaintiff's trade secret complaint. A confidentiality agreement was at issue, and the plaintiff claimed that the defendant had used information in violation of that. But going back to James's stories from before, the agreement stated that the obligations of confidentiality survived the termination of the agreement, but only for 5 years. And the defendant successfully argued that their use fell outside the scope of that provision. Unclean hands, this is the typical argument that the plaintiff itself engaged in the same misconduct that underlies its claims against the defendant. The one thing to note for trade secret specific thing is that in order for this to be a successful defense, the misconduct or the fraud or the bad faith that is raised as part of the unclean hands defense must generally relate to the trade secret that's in dispute for the unclean hands to be successfully deployed. It's usually just not enough to say the plaintiff is bad, and then that will give access to an unclean hands defense. Statute of limitations defenses come up less frequently in this area of the law. It's 3 years under the DTSA. You don't see a lot of this because, frankly, if multiple years have elapsed since a defendant started using trade secrets, there's going to be other barriers for plaintiffs bringing these claims, and it certainly would be an uphill barrier to seek and obtain preliminary injunctive relief in these situations. I think it would be almost impossible under U.S. law. And then finally, independent development. Independent development or discovery by independent invention is something that comes up quite frequently. It's a complete defense, and companies may independently develop the same or very similar trade secrets. Again, this is sort of by way in contrast to patent protection, which protects a creator's exclusive rights in most situations. And to situate the defense, independent development is directly linked to the use prong in trade secret misappropriation. If there is proof that the defendant independently developed a technique that resembles the trade secret, then the defendant did not use the plaintiff's trade secret in any way that is actionable. So that's how it relates to the plaintiff's burdens in this situation. And it's one that, as a defendant, you should think about early and in depth when these cases are filed. So we're running a little short on time. I have here a case that just, a very, very recent case about independent development. If you're curious on this, I would suggest looking into it. But frankly, the takeaway from this case is when you deploy the independent development defense as a defendant, it can be difficult if there is internal communications suggesting that is not the case. Here, there were communications by employees, even though they had, some evidence that they were developing independently this product, saying like, we hope to get this information so we could use it. So there's some best practices for independent development are to document your independent development, maintain records that you can prove that the development predates exposure to an alleged secret. Hopefully not have internal communications that were the type of internal communications that were in this case. And the last thing I'll say on this is some companies even use what is known as a clean room procedure, whereby they'll exclude from certain development processes anyone who could potentially be tainted by particular intellectual property or information. So that allows you as a defendant to really get ahead of some of the counter argument you'll hear when you raise independent development as a defense.
And I just wanted to touch upon very briefly the concept of tainted hiring. It is something that was already touched upon by Julie on a previous slide, but whenever you hire a new worker that used to work for a competitor, there's always the risk of tainted hiring, wherein that recruited worker has knowledge of that competitor's trade secrets and that they have confidentiality obligations towards that former employer. So as I said before in a previous slide, one of the bases for a trade secret claim in common law is inducing a breach of contract or interference with contractual relations. So if you hire a employee or a worker who has confidentiality obligations towards their former employer, and then you convince them to share, that former employer's trade secrets with you, that could be the basis of an action based on inducing a breach of contract. So one way to avoid this happening, and it may seem very intuitive, is just to make it very clear to this new worker from the outset that this new worker is forbidden from using or disclosing their employer's trade secrets or otherwise breaching their confidentiality obligations. You can do this by, including a clause to that effect in their employment contract and by drilling it or hammering it into them during some sort of onboarding meeting. And while this isn't really, this isn't going to prevent, or this isn't necessarily going to always prevent something from happening in the future, at least it gives you something to point to show that this is a matter that you were taking seriously from the outset as soon as this new worker was hired. And so I think that brings us to the concluding remarks portion of the presentation. And so, Julia, did you have any concluding remarks that you wanted to make?
I did. There's a few things highlighted here, and we've touched on many of them. But I'll say, if you walk away from this just remembering a few things, first and foremost, maintaining good data protection hygiene is so important. Limit access to information depending on employees' roles, have confidentiality agreements, limit downloads from company computers using a secure environment, maintain logs of who can access trade secrets. All of these things can be achieved these days with not a huge amount of cost. So again, where context, will be important, you should consider, some of these very standard security protocols, because it is not as if implementing these are exceedingly costly, and they're quite standard these days. Second, move fast when you determine that there's an issue or when you're alleged to have engaged in misconduct. For trade secret owners, identify what has been allegedly taken, secure information, document it, determine when exactly any misappropriation occurred. For those accused of trade secret misappropriation, determine how much your internal network needs to be quarantined and sort of consider whether or not that would be, in the context of the case, something that should be done. And then finally, keep trade secrets out of widely distributed documents, or if they need to be there, if the information needs to be there, make sure you're taking the appropriate security protocols around that information, because it will matter.
And just to add my 2 cents in terms of concluding remarks, it's something that we touched upon many times, but if I had to give one bit of advice in terms of a process change to use, it's just always make sure you do have a robust and well-tailored NDA, and make sure all receiving parties are actually signing this NDA and that you're keeping copies. And always make sure that you're clearly defining and labeling your company's trade secret information. And I just wanted to end on the following note. We've been giving a lot of best practices or a lot of examples of things that companies can do, but protecting trade secrets is not a one-size-fits-all project. Different businesses have different needs. But what we hope you take from this presentation is that, you start asking yourself the right question, that you take inventory of your company's trade secrets and you look at all the best practices that we have suggested, and you ask yourself, okay, should I be implementing those best practices into my business in some manner?
All right. Well, congratulations to our two panelists, Julie and James, for their time, generosity, thoughtful preparation. Your practical insights, a clear explanation, engaging discussion made the session both lively and highly informative, and greatly enrich our collective understanding of the issue. I think you made it clear that as lawyers, we educate our client about the existence, protection, and discipline related to trade secret and what it entails. Well, finally, I will look if I think there's a question in the Q&R. Let's find out. Yeah, I will read it to you. I have been told filing a provisional US patent will be a good way to keep a record of trade secret. Is that true?
I mean, I don't know if Julie, you wanted to say anything, but
No, go ahead. I think this is more in your sort of your
yeah,
wheelhouse.
I mean, it's one of those things where I don't know if I've ever recommended it, but I'm thinking now, like, I guess it could be, because a provisional application, will always remain unpublished unless you file a regular application claiming priority from that provisional. And so if you describe your trade secret information there, at least there you can say, like, well, we submitted this document to a third party on this date. And so we're able to show that at least on this, as of this date, we did have this trade secret information in our possession. I do have to wonder if there's maybe other more pragmatic ways of keeping good records, but in theory, I guess that could work. As long, again, as you don't file a regular application, claim priority, and then everything gets published after 18 months.
Very good. I don't think there is any other questions. So, thank you very much, everybody. Thanks again to our panelists. And finally, participants are warmly invited to contact me should they wish to contribute to our mutual enrichment of IP law. Thank you and have a good rest of the day. Bye-bye.
Thank you.
Thank you.
Bye.
Thank you. Bye.